The Australian legal system, like many common law jurisdictions, is built upon a foundation of common law and equity. These two pillars form the bedrock of our legal framework, ensuring that justice is not only done, but seen to be done. Common law, with its roots in historical precedents, provides a structured and predictable set of rules. However, it is equity that breathes life into the law, ensuring that the rigid application of rules does not lead to unjust outcomes. These two streams, while distinct, are interwoven to ensure fairness and justice. Equity complements common law by addressing situations where the strict application of legal rules might result in hardship or injustice. It acts as a corrective mechanism, ensuring that the law serves the people and not the other way around. While common law provides general principles and remedies, equity steps in where the rigidity of common law might lead to unfair outcomes. For instance, common law might offer monetary compensation for a breach of contract, but equity can provide more nuanced remedies that better address the specific circumstances of a case. Equity, albeit with its own unique rules and formulae, operates based on principles like fairness, conscience, and good faith. These principles guide the courts in making decisions that are just and equitable, even if they deviate from the strict letter of the common law. This flexibility allows equity to adapt to changing social norms and values. It provides remedies such as injunctions, specific performance, and rescission, which are unavailable under common law. Injunctions can prevent a party from acting in a way that would cause harm, while specific performance can compel a party to fulfill their contractual obligations. Rescission, on the other hand, allows for the cancellation of a contract, restoring the parties to their original positions. These remedies are essential tools in the pursuit of justice, providing solutions that are tailored to the specific needs of each case. One of the most significant areas where equity holds sway is in the realm of fiduciary relationships. These relationships are characterized by a high degree of trust and confidence, and equity ensures that this trust is not misplaced. These relationships, built on trust and loyalty, are the bedrock of countless personal, professional, and commercial interactions. Whether it's a trustee managing assets for beneficiaries or business partners working together, equity ensures that these relationships are conducted with integrity. Equity plays a vital role in upholding the integrity of these relationships. It imposes fiduciary duties on those in positions of trust, requiring them to act in the best interests of their beneficiaries. This ensures that power is not abused and that trust is maintained. It ensures that those in positions of trust and power do not abuse their position for personal gain. Fiduciaries are held to the highest standards of conduct, and equity provides the means to hold them accountable. This is where the concept of fiduciary duties comes into play. These duties are fundamental to the functioning of equitable relationships, ensuring that fiduciaries act with loyalty, care, and good faith. These duties, rooted in the very essence of trust, bind fiduciaries to act in the best interests of their beneficiaries. They must avoid conflicts of interest, act with prudence, and always prioritize the welfare of those they serve. In this way, equity ensures that trust is not only earned, but also preserved. In essence, a fiduciary relationship is a relationship of trust. It is a bond where one party places their confidence and reliance on another to act in their best interest. One party, the fiduciary, as said by Justice Mason in the leading judgment of hospital products, undertakes to act in the best interests of another party, the beneficiary or principal. This responsibility is not taken lightly, as it involves a commitment to prioritize the beneficiary's needs above all else. The essence of this relationship is vulnerability. The beneficiary is often in a position where they must rely on the fiduciary's expertise, integrity, and judgment. The beneficiary places trust and confidence in the fiduciary, often with significant interests at stake. This could involve financial matters, legal decisions, or personal affairs that require careful and considerate handling. This vulnerability necessitates the imposition of stringent duties upon the fiduciary, ensuring the beneficiary's interests are paramount. Fiduciaries must navigate their responsibilities with a high degree of care and diligence. These relationships are not confined to legal documents or formal agreements. They can emerge in various contexts, including personal, professional, and even casual interactions such as conversations between a doctor and their patient. They can arise from informal arrangements, mutual understandings, or even the conduct of the parties. the nature of the relationship is defined by the expectations and trust placed by the beneficiary in the fiduciary. The key element is the existence of a relationship where one party is entitled to expect that the other will act in their best interests. This expectation forms the foundation of the fiduciary duty. Recognizing the vulnerability inherent in these relationships, equity imposes strict duties on fiduciaries. These duties are designed to protect the beneficiary from any potential abuse of power or trust. These duties go beyond mere honesty and require fiduciaries to act with utmost loyalty and good faith. They must avoid any conflicts of interest and ensure that their actions are always aligned with the beneficiary's best interests. They must prioritize the beneficiary's interests over their own and avoid any situation where their personal interests might conflict with their fiduciary obligations. This level of commitment and integrity is what distinguishes fiduciary relationships from other types of professional or personal interactions. In summary, fiduciary relationships are built on a foundation of trust, confidence, and a commitment to act in the best interests of another. Whether formal or informal, these relationships require a high standard of conduct and a dedication to the welfare of the beneficiary. Understanding the nuances of fiduciary relationships helps us appreciate the responsibilities and ethical standards that govern these important bonds. It reminds us of the profound impact that trust and integrity can have in our personal and professional lives. As we navigate our own relationships, recognizing the principles of fiduciary duty can guide us in fostering trust, loyalty, and mutual respect. Over time, equity has identified certain relationships where the inherent nature of the relationship gives rise to a presumption of a fiduciary obligation. These are typically relationships where one party is inherently in a position of trust and confidence vis-a-vis the other. These presumed relationships provide a degree of certainty and predictability in the application of equitable principles. Some common examples of presumed fiduciary relationships include trustee and beneficiary, solicitor and client, director and company, and agent and principal. The authority for this statement is again in the leading judgment of hospital products, specifically Justice Mason. In these relationships, the law presumes that a fiduciary relationship exists due to the power imbalance and the trust inherently placed in one party by the other. However, it's crucial to note that this presumption is rebuttable. The onus lies on the party asserting that no fiduciary relationship exists to prove that, despite the nature of the relationship, no such obligation arose in the particular circumstances. Establishing fiduciary relationships on the facts. Not all fiduciary relationships fall neatly into these predefined categories. In many instances, the existence of a fiduciary relationship must be determined based on the specific facts and circumstances of the case. This is where the courts delve into the nuances of the relationship, examining the interactions, expectations, and undertakings of the parties involved. The courts look for indicia, as said by the leading case of Breen and Williams, of a fiduciary relationship, such as an undertaking to act in the interests of another, a relationship of trust and confidence, bargaining power and equity, where one party undertakes to act in the interests of another, an element of vulnerability or dependence, and the potential for one party to exercise discretion or power over the other's interests. The presence or absence of these indicia helps the court determine whether, despite not falling within a presumed category, the relationship warrants the imposition of fiduciary duties. This factual analysis ensures that the protective umbrella of equity extends to relationships where trust and vulnerability exist, even in the absence of a predefined legal label. Unlike our Canadian counterparts, the duties of fiduciary relationships in Australia are proscriptive and not prescriptive. That is, they restrain unauthorised actions instead of requiring certain actions to be performed. The two fundamental duties of an Australian fiduciary are to act without conflicts of interest and to not earn unauthorised profits. In terms of the duty to act without conflicts of interest, this is possibly the more straightforward of the two duties. One, as fiduciary, needs to ensure they remain untainted by the real and sensible possibility, as said by the leading case of Boardman, of conflict. Conflicts generally take two main forms: conflict to self, and then conflicts of duty. conflicts to self are self-explanatory. They are the conflicts of interest, which puts the fiduciary's own interests in a battle with the interests of their principal. For example, if the fiduciary is earning a secret commission that is unknown to the principal, he has an interest in maximizing financial benefit to himself as opposed to getting the best deal for his principal. This is an obvious conflict. Duty-duty conflicts, on the other hand, are when the fiduciary owes conflicting duties towards at least two different masters. For example, if a solicitor represents both sides of a heated litigation, they cannot discharge their duties to one party without harming the other. The duty to not earn unauthorized profits, however, is slightly different. This duty requires that the fiduciary not make any financial benefit in their position as fiduciary without the total and informed consent of their principal. Note now that the lack of bona fides is not required for breach to be established, merely that profits were unauthorized. Please also note that breaches of fiduciary relationship are only established if the breach was in the scope of the relationship itself. Breaches of duties outside of the relationship will not be considered by the courts of equity to be breaches of the relationship. In an extreme example, a solicitor who punches their client in the face may well face criminal or tortious sanction, but they will not be liable for breach as fiduciary. This contrasts with another example where a solicitor does not tell their client that they took a bribe to lose their client's litigation. This is definitely breach of the fiduciary relationship itself. In brief, the two main remedies available for breaches of the fiduciary relationship are an account of profits and also equitable compensation. This being said, a more detailed explanation of equitable remedies will be supplied in another video. Thanks for watching.